gentlemen, thank you for being here tonight. We really appreciate it. I'd like to do some introductions before we get started. First, I'm Tom Squares. I'm the Regional Vice President. I'd like to introduce you, for those of you who don't know, Carl Kohanek, who's the President and owner of ACM and allows us to do these seminars for the benefit of all of you. So we really appreciate you being here. We hope we're going to have a good program for you. Viviana, you all met when you came in here. She's our Director of Marketing and Special Projects, and she helped put the program together, so I'd like to thank her. We have a couple managers and customer care people here. So we have Chris and Karen from our customer care division are here. We have Teresa, one of our managers. We have Alan, one of our managers. I think that's all of our managers. So I thank them for taking the time out to be here also. And right now our presenter, Pat Costello from Key & Costello, is going to be here, and we're kind of waiting on the police officer, Julie Smith, who's supposed to be here, and she's missing in action right now. So Pat will be able to ably handle the entire program if he needs to, but we're going to go ahead and start. So the topic for tonight, as all of you know, is crime-free multi-housing and condominium rental policies. And the crime-free multi-housing program is designed to keep illegal activities out of rental units or rental properties. These programs are designed to help landlords, owners, residents, and managers of associations where there are rental units or homes to keep drugs and other illegal activities out of the associations. These solution-oriented, state-of-the-art programs are designed to reduce crime in residential properties and improve their quality of life for the people that live there. One part of the program is effective rental policies and procedures, which Pat's going to go into more in depth, including screening of potential renters and property qualifications. This program started in 1992 in Mesa, Arizona, and the crime-free programs have now spread to over 2,000 communities throughout the United States. I also understand there's some programs in Puerto Rico and some other countries also. So it's taking off, and I think it's a great program. And again, Pat's going to tell you more about it. So I'd like to take a minute here to introduce Pat Costello. He's one of the founders of the firm Key & Costello. For those of you who don't know, he is an attorney with offices located in Wheaton and Batavia. And since 1993, Pat has concentrated his practice in the area of association law, representing condominiums and community interest community associations. He's a member of the Federal Trial Bar for Northern District of Illinois. He practices and appeared in courts in DuPage County, Kane County, Will County, Kendall County, Lake County, and Cook County. So he's a busy man. He's never home. Pat is also a member of the State Bar Association of DuPage County, and he does a lot of lecturing and presenting for ACTA and CAI, and Pat currently serves as a co-chair of the CAI Illinois Legislative Action Committee. So without further ado, I'd like to welcome Pat Costello to the podium.
Thanks, Tom. Before we completely get started on the program, just so everyone is clear, I always think that these programs are a lot better when it's interactive. So while we can have questions at the end and we can summarize some things, if you have a question, if something pops into your mind about something that I'm saying or something that somebody else is saying, raise your hand. If it's something I'll be covering a little bit later, I might say, well, okay, hold on a second, we'll get back to that question in a couple of minutes. But otherwise, I don't want you to have to wait till the end of whenever I'm done speaking and say, hold on, I think I had a question about something you said in the first 5 minutes when I can't recall. So often when somebody asks a question, it can spur another question or spur another thought, or we can all learn from one another by examples and by situations. When Tom asked me to present on this topic, I thought, well, this is pretty unique because it's an interesting area where I think associations more and more are becoming active in crime-free housing. Because I think at first blush, a lot of people say, well, hold on, that's for landlords, that's for apartment complexes, we're not involved in that. That's a false impression. As I point out in some of the information that I put out there, a lot of communities shifted demographically after the real estate market kind of collapsed. And when I say shifted demographically, they just got a lot more investors. As foreclosures hit communities, some of the communities I represent, it went from 2% foreclosures, 1 or 2 foreclosures, to low and Who came in and bought up all these foreclosures? Well, it wasn't a lot of people who moved in. It was a lot of investors who saw an opportunity to come in, put their money down, and get it. Nothing wrong with investors in your community, not necessarily. Now, if we have a chance a little bit at the end, we'll talk about other types of leasing restrictions. But crime-free housing is generally applicable to communities that don't have a leasing prohibition. You have landlords, you have investors, you have tenants in the community. Now, I always say the same thing. You can have great tenants and terrible owners just as well as you can have great owners and terrible tenants. Just because someone's a tenant in the community and just because someone's a renter doesn't mean in and of itself that's going to be a problem. I know a lot of communities where somebody can say, geez, so-and-so's lived here for 8 years, they're the nicest people in the world. They take care of the property better than some of the owners who seem to come and go and not really care about the upkeep of their units. I think it's important, though, to know that as you add investors to the communities, the likelihood of getting a bad tenant every once in a while, getting somebody who's only going to be there for 12 months, 6 months, 9 months, increases. And their concern and their care about the standards of the community, the way other people who live there, might go down. Also, for other investors, if you are an investor in the community and you work really hard to make sure you do great and get good tenants in there and you screen those tenants, if the rest of the neighborhood turns into something that you wouldn't want to live next door and you wouldn't want your tenants to live next door to, your investment decreases because it becomes harder to rent in that neighborhood if it gets a bad reputation. It certainly becomes harder to sell, but it also becomes harder to rent. So that's why we start talking about some of these crime-free housing. Everybody thinks, well, crime-free housing, of course. Why? What would be the opposite of crime-free housing? Crime housing? We certainly don't want that. No one's in favor of crime housing. So municipalities develop these programs. As Tom pointed out, first in Mesa, Arizona, and I think the first large municipality locally that did it was Schaumburg. And they were having some problems with some of the apartment complexes. So they developed these programs. Why? They wanted to certify communities. They wanted to educate landlords. They wanted to have certain addendums added to the leases so it was easier for landlords to get problem tenants out of the property. Tenants who might still be paying rent, tenants who might be living in that gray area, but tenants who police just always seem to be out of that property. There's been somebody who's, they're not really on the lease, but they're there, and lo and behold, they were arrested. Those types of things for landlords could become problematic, and sometimes those would take months, maybe even longer, to get that tenant out of that property. That's a fight between the landlord and tenant, and it's wreaking havoc on the rest of the people in the community. So I always see, especially for associations where they can use this, is it's generally not a community that all of a sudden is 50% renters and there's crime going on everywhere. That's not what I see very often. We've seen that in a couple of communities, but that's rare. What it is there's 1 or 2 units that are just operating on a completely different set of rules. And there's cars coming and going all times of night. You don't know who's quite living there. You see things that look like crime activity. You see things that look like drug activity. There's domestic violence going out of there. You hear, noises at night. You hear doors slamming and screaming and yelling. And then all of a sudden you're saying, what do we have going on? And this is where the associations come in. Let's take a broader step. For associations, if you have crafted a set of rules and regulations that are operating properly, you are, as an association, the de facto super landlord. So there is the tenant, there is the landlord, and then the association acts as the super landlord. What do I mean as the super landlord? The association can enforce its set of rules, regulations, covenants against that tenant. You don't have to just go to the landlord and say, landlord, please take care of your problem tenant. Landlord, please stop the police from coming to the tenant's office or tenant's unit all the time. It's not going to be that effective. Because sometimes we get landlords there who just want to collect the rent check. And as long as the rent check's clearing every month, they don't really care. And if there's a violation here or there for $25, they'll pass it on to the tenant and the tenant will pay it. But it doesn't solve your problem. It doesn't take care of the issues. It doesn't make it easier for the people who live close to them to come home at night and say, I just worked a 40-hour week. It's 5:30, 6 o'clock. I just want to come home. I want to have dinner. I want to go to sleep. I want to get up tomorrow and do this again. I don't want to have to deal with all of this nonsense. Depending on the way the community is set up, and I've seen it happen in single-family homes too. It doesn't just have to be, the traditional condo buildings with a shared hallway and people going all over the place. I've seen it in single-family homes where that home has lo and behold become the property that something's going on. So communities adopted these crime-free housing. What they did is they set up seminars, they work with the police department, they provide you with addendums to use for lease agreements, they certify landlords. I know in Aurora, if you want to be a landlord, you need to go to these programs and become a certified landlord. In Naperville, they have a program where this can become, your community can become a certified crime-free housing community. Outside of the municipal programs, though, associations can do other things. If you want to have enforcement, what do you got to have first? Rules. Exactly. So let's talk about that a little bit. Before you can actually start thinking about how you're going to enforce this, you have to create and craft a set of rules. And those rules won't just apply to the landlords, but they'll also apply to the tenants. Well, they'll apply to everybody. They'll apply to everybody equally. And if somebody happens to be renting their unit, they'll apply. So whenever you're looking at a set of rules, be it parking rules, leasing rules, really I think it's incumbent upon a board to determine what's our objective. What do we want to accomplish by this rule? And how do we want to do this? And is this something that people are going to be supportive of or people are going to reject? If you say, okay, crime-free housing, again, I don't think there's going to be a lot of people who are going to come in and say, no, I'm against that for crime-free housing. I'm in favor of crime housing. So you probably actually, on an objective point of view and from a marketing point of view as a board, you're going to be successful up front trying to put that in place. But then how do you go about doing it? Because you want to do it in a way that affords you the protection, that doesn't step over any lines, that doesn't violate any other laws, and puts enough teeth in it that you can accomplish something, but doesn't make it so difficult that management and the board start saying, to heck with it, it's just too hard and we can't do it. Because rules like covenants, if you're not enforcing them, they will lose their strength to enforce them. Quick introduction?
Sorry,
Very
Julie.
thorough.
Why don't you get sit right up here and I'll introduce you later.
So let's just generally talk about managing rentals. Both the Common Interest Community Association Act and the Illinois Condominiums Property Act have a very simple provision regarding rentals, and it is that landlords must produce a copy of the lease within 10 days of the lease. Period. Why? So you can know who's there. Sounds simple enough. I mean, if you need to get into a unit, if there's an issue with the unit, we need to have a name and a phone number. We need to be able to know who's there. You should be mandating that. You should be enforcing that. You don't even need to enact a rule to do that. It's already in the law. They have to do that. And if they fail to do that, they're in violation of the law and could be subjected to having their tenant removed. Yes, ma'am?
You're saying it's in the state law?
Yes. 10 days. Yes.
Do you know which section?
Which?
Reference it?
For a condominium or a condominium?
Condo.
For a condominium, it is at the very top on the second page of the documents you have in front of you. It references section 18 and in the Illinois Condominium Code. And it's section 1-35A of the Common Interest Community Association. Now, just providing a copy of the lease just gets you information. It doesn't really allow the association to set the parameters by which this tenancy is going to be. You have covenants against owners. You have obligations against owners. You have rules that apply to owners and tenants and their guests. But how does a tenant know that? That's what you include in your rule set. One of the things you want to include in your rules is an acknowledgement by the tenant that they've received a copy of the rules and regulations, that they've received a copy of the declaration, that they've received a copy of the bylaws. Why? Because they're going to be bound by it. The owner might not even live on the property or have any idea what's going on there. This is where, as an association, you can create a package of material to have that. And this is where the crime-free housing addendum can come in as well. Because you tell the landlord, as part of the lease, we are going to say in our rule that anytime a landlord leases their property within this association, as part of the lease, the tenant must sign this document. And if the tenant fails to sign that document, or the landlord fails to tender that document to the association, just like the other provision when we fail to tender a lease, the association can then send a letter to the landlord and to the tenant saying, in violation of our governing documents, and you must get out. Now, they can cure that by providing those documents, but that is something that you can send to that tenant to make sure that that tenant is aware. Yes, Rich?
Yeah, and it'd be good for like put a smaller section together where you give somebody the declaration and talk about the reason for somebody to do, let alone for a tenant to do maybe just basic rules or whatever.
You know, I agree with you about declarations. I have to read them, but if I didn't have to read them, I probably wouldn't read them. Rules and regulations are something that's usually written, I would say, in English, and most people can actually comprehend that. Why I want that tenant to sign that and that full copy is because that might come back later. So if that tenant comes into court at a later point in time and says, well, I had no idea that there was this type of restrictive covenant that I've been violating for the last 6 months, you'd say, well, it's in the declaration, you signed the document, that you have received a copy of it. And having that piece of paper on file with the association gives the association a little bit more authority when the tenant tries to make the argument that they didn't know what was in there. And courts generally say, well, if you had it and you chose not to read it, that's your fault. If nobody gave it to you, well, that might be somebody else's fault. But you signed a piece of paper saying you had it. Yes, ma'am.
Would there be any concern about electronic delivery versus print delivery? Is that
No.
ever an issue?
No, I think that's fine, as long as you get some type of attestation or something from the tenant that says, hey, I've received this. And that's where you can put together a package for landlords too. And coupled with that package, like I said, is a lease agreement. Then, as part of a lot of these crime-free housing programs, they talk about the landlords. Listen to me carefully. The landlords obtaining a background check on the tenant. Now, here's why I say that. There are associations that want to obtain a background check on a tenant. My first question is, for what reason? Are you telling this tenant they can't live there? If you're obtaining a background check on a tenant, telling the tenant that they can't live there, association, let your insurance company know that you're doing that because you're going to be sued for discrimination suit. Don't. Make your rule require the landlord to obtain a background check on that. And you don't even vet it. Maybe you just want to get a copy and put it in your file, and that's it. But the landlord then is on the hook to make that determination as to that background check on the tenant. Sometimes what we've seen is then the landlord maybe takes a second look at it. But when associations start telling people they can and cannot rent based upon what they might see on a background check, I know it's coming. I know you're going to, it's very easy to fill out a discrimination case with the EEOC or the Department of Human Rights. And people can do it on their own, and it gets very expensive for associations to defend those suits. So that's the procedure that I would recommend. The addendum, yes, ma'am?
I just had a question on the requirement that the owners provide a copy of the lease. Is that applicable if a association is not self-managed? So if there is an outside firm that is, in other words, is the requirement boiled down to the manager, which also provide a copy of that?
Well, that's something that the board would work out with the management company as to whether or not they want copies of all those files. I don't know, how much stuff do you want? Is it enough for the management company to say we obtained a copy of it, here's the name of the tenant? For some tenants, probably most tenants, you'll never even need to know their name. They're the nice people who come in, park their car, pick up after their dog, and they're fine. It's only when it becomes an issue that you want them to be able to go to management and say, okay, we're having an issue with this tenant.
What are the things that are included in that motion? Is there a form signature?
I'll kind of touch on it when I speak, but it's going to be everything in their criminal history, right? So anytime that they have been convicted of a crime, it's going to show up in their criminal history.
Yeah, those are the typical things they're going to show. Criminal act. I mean, quite frankly, it's not going to be conclusive, but you're probably going to go to a Google search in a lot of ways to find out if someone's involved in other things. Yes, Rich?
Yeah, for all those things on like the background checks and stuff, it's not open to all board review or look at.
Oh, it would be open to the board, it wouldn't be open to the membership. So the membership, that wouldn't be one of the documents that would go into a homeowner's file that that anybody on the membership, either under the Not-for-Profit Corporation Act, Common Interest Act, or the Condo Act, they would be entitled to see.
Well, would they just basically go to the management company? I mean, not necessarily.
Depends on the procedure that you want to set up with the board. Yes, ma'am?
I just want to be clear on this. You're
Okay.
saying you advise us to put a rule in place requiring background checks. But because we're not requiring a background check, that protects us.
You're not vetting the tenants.
So we're not, there's some chain of liability and all that stuff.
All you're doing is, as part of creating your file, asking the landlord to give you a signed copy of the lease, the crime-free housing addendum, and a background check. So you put that in your file, and you close the file. But you're not telling the landlord, oh, this came back on the background check, and we looked at it, and it looks like this person had a misdemeanor burglary in 2003, so you can't have that person as your
We
tenant.
just want a copy, we're making no judgments.
Right, exactly.
One thing that we did, we went crime-free 5 years ago. We actually specified the website we wanted them to
Sure.
use because it's amazing what you get when you just say, okay, send me, a background check. We had it written out in cursive. I checked on this person and he's okay.
Yeah,
We actually specified the site they had to use.
And then-
We did not take anything else.
and include that in your rules and regulations so that you can then say, this is part of our process, and this is what, and then you don't risk saying, okay, where'd you get this piece of information? So you put together these documents, you create this package of material, but here's the thing, and then you do it. I mean, you gotta do it every time. It has to be something that's part of the process. You gotta communicate it to the owners that it's a process, then you gotta communicate it again, and again, and again, and again. You gotta put it in newsletters, you gotta remind people about it at annual meetings, and you have to tell the other homeowners, hey, if you happen to see somebody walking around over here who you don't recognize and is not an owner, shoot us a note. And if management then says, oh yeah, somebody bought, welcome your new neighbors, fine. But then sometimes management says, I mean, they're not out on site all the time. These might be people who are coming home at 6 o'clock at night and say, oh geez, that person's got a new tenant in there. We need to now communicate to the owner. We need a copy of that lease on file. There are some innocent times that owners just don't do it. Maybe they're the first time landlord, maybe they're the first time investor. Should they? Yes. Do they sometimes make that mistake? Yes. But you know what? After a couple reminders, and I'm sure the managers can tell you that, the owners who are trying to get around it. I mean, the ones who you send one letter to and say, oh my gosh, I'm so sorry, here's a copy of all the documentation, now let me get it into you. Those are the ones that you're not going to probably have a problem with in the future. Yes?
So you have an association that already has some tenants in there, you can't go back and say,
Sure you can.
you can't.
Sure you can. Well, it's been, the law's been in place, Common Interest Act since 2010, and the Condominium Property Act, I think that provision's been in there since the 80s. So technically, if they didn't produce a copy of the lease the first time, they violated the law. But maybe nobody asked them. But you could still say, you have a tenant in the property, we looked at your owner file, we don't see anything in the file that shows a copy of a lease, please provide us with a copy of this. One of the ways that I've seen other management companies do this effectively is they just say, maybe it's time for a census. And everybody gets a census. And then lo and behold, when you get the census, you can find out that this person doesn't live there anymore. Or the people who are in there are, these other people whose name I've never heard. Well, lo and behold, guess what? They're renting their unit. Maybe they innocently didn't tell you, or maybe they intentionally kept it quiet for whatever reason. But in order to even start talking about enforcing some of the crime-free programs, you need to have these policies and procedures in place, and you need to make sure that you're following them. That's right.
Can the board mandate a census at any time?
Yes, a board can adopt a rule that says that they will take a census. And then it would be a violation of that rule for failure to respond to the census. And then you could fine somebody for failure to respond to the census if you wanted to create that process. Talk to your property manager first. Sorry, all property managers, I'm just saying.
But I don't think that it's in the DERS rules
Right, it would have,
Just a policy
Well,
and
then-
an operating.
right, and if it's just a policy, if it's just something we send out, then if somebody doesn't send it back, you really don't have any teeth.
Right.
That's the problem. If it's not in a rule, it's just, it's voluntary, and you hope everyone does it, and you just kind of keep sending it until they eventually turn around and send it back. So we've created this rule, and the association's decided it wants to be part of a crime-free housing program in this municipality. It's adopted a rule that says an amendment. Now, don't forget the rule process. So if you're a condominium association, it's very specific. You need to provide a copy of the draft rule 30 days in advance of the meeting, hold the meeting, adopt the rule, then tell everybody that the rule's been adopted. Then it has enforceability. The Condominiums Community Association Act is a little less specific regarding the timing, so I recommend you follow the same approach. Send it out in advance, have an open meeting, adopt it at the open meeting, and then enforce it after that. That way you have something in place. Because if a rule's ever challenged in court, that's the way I would first challenge it. How was it adopted? Was it just something that a couple of board members wrote one day, sent out to management? And if you haven't gone through the steps of doing it at an open meeting, if people had notice in advance, it could be susceptible to challenge. You don't want to after you've been enforcing it. The worst thing that can happen with a rule is somebody a year or two later challenging it and winning. Because then everybody else says, the heck with it, the board can't do that. See, that guy fought him and they learned the board can't do that, so we don't have to produce any of those things. So you've put all these documents in place, and you've papered your file, and you have everything, you have the information, and now lo and behold, you have a crime, you have a problem. You have that unit that's becoming an issue. What's the first thing we do? Okay, it's an immediate issue. What's the first thing you do?
Send a violation.
Say it loud, please.
All police.
Exactly. Exactly. Call the police. If it is an issue, call the police. Management can respond to situations very quickly. They're not the police. I can respond to things not as quickly as even management. I'm not the police. I can't solve a problem on the property. Call the police. Don't call management first. Don't call the attorney's office. Call the police. They will work to settle down the problem as it exists right now. They will create peace, which is what you need first and foremost. So you've created peace, but it's just a perpetual problem. The police keep getting called out there. And there's nothing that we can really hang our head on. Or, lo and behold, somebody, not the tenant, maybe not somebody who's even listed on the lease, lo and behold, starts getting arrested at the property. There's a criminal investigation. So the association sends a letter to the landlord. It says, hey, your property's got a ton of police activity. We've sent a FOIA request to the police department. We have these police reports. We know they've been out there 5 or 6 times in the last 5 months. What are you doing about your tenant? Landlord's not responsible. Either says nothing or says, I'll take care of it, and doesn't. Why? Again, getting rent. So they're okay with it. This is where the concept of the association being a super landlord kicks in. So now you have this wonderful rule. And usually the way associations deal with rules is you have hearings, you have fines, you have those kind of things. And all that process works, but it usually doesn't work to prevent or stop or remedy crime. If it is an issue that is not crime related, somebody's not picking up after their dog, somebody's making, parking in the wrong space repeatedly, somebody hasn't provided a copy of the lease, someone's not providing the information, somebody have an occupancy provision in there, somebody has way too many people in the unit, you can deal with some of those things by rules and regulations. And I recommend that before you go to court, some of those things through rules and regulations are a better way to do it. If you have crime on your property and you're constantly dealing with the police on it, or even repeatedly dealing with the police on it, then there is a mechanism in the law for both common interest communities and condominium properties for the association to evict that tenant. Evict that tenant. There's a procedure in the Forcible Entry and Detainer Act to remove that tenant for violating the association's documents. And this is where the crime-free addendum kicks in. Because the association, like I said, is the super landlord now. So if there's a term in that addendum, that lease addendum between the landlord and the tenant, that the association had them sign, that says, and I produced a couple copies, that says a provision in there that crime will not occur on the property, that tenant has violated that provision. And there is a mechanism by which it has to happen. Just like a landlord gives a 5-day notice for non-payment of rent and a 10-day notice for violating the lease, the association sends a 10-day notice. And that 10-day notice goes out to the tenant, carbon copying the owner. That's why it's important to have his addresses. If we don't know who the tenant is, we can send it to unknown occupants. We send it certified mail. They don't have to retrieve it, we just have to send it. If after 10 days they have not come into compliance and these activities are still going on out there and they have not left the property, the association can institute an action, enforceable entry and detainer, to evict the tenant and seek all of its costs and attorney's fees against the owner, to remove the tenant for violating the rules, the declaration, or the lease. Yes, ma'am.
I have a different situation.
Okay.
What if an owner takes in a friend, a boyfriend, shady character, which I'm nosy, and I can find things out and pretend, oh, nice to meet you, and so but. And he actually has been sort of homes
It's much more difficult.
visits by the police.
Yep.
One time the gun's drawn, one time, just
You're not going to have the rights to evict that person, because the only action that you're going to be able to evict an owner from their property that they own or from somebody who's occupied with them is for the non-payment assessments. But as long as they're current on assessments, what you would have to do, what the association would have to do is file an action for injunctive relief, which is a more extensive process. And that action, you would ask the board to enter an order prohibiting that person from coming back on the property. That's not an easy, simple, fast case.
But an association has a right to know who's living
Correct.
on the property, even if somebody moves in with an owner and has, I don't know, like a 3-day house guest that you get rid of anyway. But, you know, when somebody comes and actually
But if you don't have,
lives with you,
if you don't have some kind of a census in place or some kind of
Right.
requirement that anybody who lives out there has to be disclosed, then no.
well, we do.
Okay, well then they're not following it.
They're not.
Unfortunately, the remedy for that isn't evicting their guest. The remedy for that is going through the fine procedure and fining them $25 for every time they won't turn it over. Not great, I know. So as owners, it's more difficult to have that. It's not impossible. And it's not even impossible for owners who are causing property. I mean, we've obtained orders basically asking the court to tell this person that if they do X, Y, or Z anymore, they have to sell their unit and leave. Rare, and usually not quick. I'm talking year, 18 months, 2 years of litigation over those types of things.
I mean, even not to that extent, but the fact that somebody has moved in, he's been there over a year. You know, what people do is their business, once it affects the whole property.
Then you need to start sending out violation notices and proceeding against the owner for causing a nuisance on the property, for creating problems for the community. Yes, ma'am?
Can you speak to the issue of owners, children, or relatives there? Because I can think of one situation, I don't know many, but this one in particular feels it does not need to produce a lease because it's a family member, it's not living there. Is there a distinction?
That's a great point. Now, one of the things that we recommend when an association is drafting guidelines for a census or disclosure or some type of acknowledgement is if you have some type of provision that would say, well, you know what, we don't want to get into this with a family member, whether or not it's a lease or you're just letting them live there. You can have in your rules and regulations that says whoever is occupying the unit, regardless of whether or not it's a lease and you need to provide it in 10 days, we need to have that information on file with the association within a certain number of days.
So it would be requesting a copy of the lease in that situation, it would be an occupancy.
Right.
So perhaps the second rule.
A separate rule, right. I have associations that have leasing prohibitions, and some of those leasing prohibitions, they'll contain language saying if it's for a family member, it's not considered a lease for purposes of this prohibition. However, we still want to know who that family member is, and maybe they're making their car or a phone number in case of an emergency for us to be able to get in touch with them, or a leak, or we need to enter the unit, so we still need some of that information, but that should be included in your rules and regulations as well. Yes, ma'am.
When you send, because I have a kind of different, when you
Okay.
send a notice to the owner that their tenant
Yes.
of circles, you need to specify which rules you're in violation of.
Great question. The law doesn't say that you need to. However, I recommend that you do. Because that letter, at some point, will be the jurisdictional requirement that allows me to get into court. And at some point in time, if I'm going into court and I'm saying, yeah, I just said they were violating the rules, and now I'm going to start dragging these people in here and say, well, they did this, and they did this, and they did this, the judge's going to say, well, how the heck did they know all this? When did you tell them this? When was this communicated? So let's talk about that a little bit. One of the things that, it's great for a manager to call me and say, you know what, so-and-so's causing a ton of problems. Their nephew who's living on the property has been arrested. They signed the crime-free housing addendum. Let's go ahead, send them the 10-day notice back. Excellent, send them the 10-day notice. And it includes on there, numerous incidents, police activity. We get the police reports, so we know that it's actually legitimate. And we include that specification on there. Now I go to court, okay? Judge says, why is this here? Well, we're trying to evict this person. What do I do? Well, you know what? Teresa comes to court with me. She's a great property manager. Guess what? She doesn't live there. So she can testify and say, I know this person lives here, I know this person's the tenant, but I can't ask her questions about what's going on, what's happening. I need people in the community. So one of the things that our office usually pushes back a little bit from that 10-day letter before we file that lawsuit is we say to management, we say to the board, we need witnesses. I need someone who's going to be willing to come to court, stand before the judge, and describe what's going on. And sometimes, unfortunately, that's where we run into some problems. Because people say, no, I don't want to do that. I don't want to take off work. I don't want to say anything. God forbid they don't get evicted, and I got to live next to them, and I don't want to get involved in that. Well, then it becomes one of those situations where you can call the police again when there's the next problem, but I can't get this person out of here. So when these complaints come in, I'm not just putting it on the manager, I'm putting it on the board members too. Talk to the people who are complaining and say, we will do something. We have the mechanism to help you. We can get you into court. You got to come in and talk. You got to be willing to testify. It's not going to be onerous. It's going to be 20 minutes in an afternoon sometime. But it's going to require your presence. You're going to need to explain to the judge what's going on. Because otherwise, we won't win.
Okay, so the wrinkle we have is we're a 24-unit building. We have one unit that is, one of the units, the problem unit, is rented out. Have a copy of this, the two tenants are, the challenge is that one of the tenants actually already violated 3 rules last week. He was opening the secure door, he had a dog in the lobby, and he's in pajamas, which is kind of simple. But we might have to fix that. But they are a unit.
Non-pajamas.
Yeah, well, this is how old the rules are. But their specific unit, on various occasions, there has been a pretty strong aroma of marijuana floating through the walls. And at one point, they left it and it became somewhat of the offending substance. Now, we are not looking to create an issue. Whatever somebody wants to do with the privacy of the company and the company is completely fine. But we don't specifically have a rule that says, well, please do not smoke marijuana. Which, I don't want to start putting that. That's where.
You do. You do. And I'm going to tell you why you do, because forget the word marijuana, but you shouldn't have smoke emanating from your unit. Tobacco, marijuana, whatever it is. I mean, for all you know, these people might be able to smoke marijuana through medicinal purposes. They might not be committing a crime by being in their own residence smoking marijuana. So rather than focus on the fact that it's marijuana, I highly doubt it, but maybe let's presume that could be true. Rather than focus on the fact that it's marijuana, you don't want any kind of smoke emanating from their unit. Be it cigarette smoke, be it marijuana smoke, be it cigar smoke, whatever it is. That rule I wouldn't put in place. Now, if you say they've already violated the rules, well, some of the things, they took their dog out, or that's a letter in my opinion. That's a letter, because some of the things might say, hey, listen, believe me, I'm not standing in front of a judge saying there's a guy walking around the hallway with pajamas, and we need to evict him. It's not happening.
And we can't conclusively prove that the owner's actually being copied of rules.
Right.
We're kind of trying to take the high road right now and say, you just, as an FYI, a reminder,
Right.
these rules.
And I think that's a good way to start. If it keeps going, then you probably need to take it the next step. And remember, when you send this 10-day letter out, it's not full steam ahead necessarily. You might send the 10-day letter out, and you might get a phone call from the owner saying, oh my gosh, I wasn't aware of this, I'm so sorry, I've talked to my tenant, I'm trying to do something about it. The tenant might call you and say, usually the tenant calls and says, why am I being evicted? What happened? Especially when the owners don't produce a copy of the lease. The tenant calls and says, oh my gosh, why am I being evicted? I just gave this person first month's rent security deposit, now I'm being evicted. Well, call your landlord. They're not doing what they're supposed to do, and get that taken care of, because I assume they're going to want to continue to collect rent. So even in that 10-day period, we might be able to solve the problem, okay? If it goes on further though, we might say, you know what? We don't have to file suit on the 11th day, I guess is what I'm saying. We can file suit now if it's 9 months later, and you say, now we're having problems again with the tenant. I'm not going to say, well, let's go back to that 10-day letter I sent 9 months ago. I'll probably say, it's only 10 days, let's send another letter before we go out there. But, yes ma'am.
My question about all the legalities of that, are you referring to the state of Illinois only? When you're saying, you're sending the 10-day letter, it's done by law? all
Yes,
that kind of stuff.
like you,
So, I'm from Wisconsin.
okay.
And so that's where my association is. I know sometimes schools are different, but it's exactly the same problem.
It's the same problem, right?
So.
Off the top of my head, I can't tell you that I know what the Wisconsin Association law provides in terms of turning over a copy of these, but I can tell you this. You can put, if it's not in the law, you can put it in your rules and regulations. You can put it in your covenants, and you can enforce it against people then. So regardless of whether or not it's been codified, the association can make that a policy going forward. And on something like occupancy, I think you can go backwards with it too. You can say any unit that is not owner occupied at this point in time, we need a copy of the lease. And if they say, well, that lease was signed 5 years ago. Okay, we're not saying you violated the rules 5 years ago. 5 years ago, we didn't have this rule in place, but we do now. And if you don't give us a copy of the lease now, we're going to pursue you. Yes, sir.
As a board member, if you're talking to an owner and saying, we need you to be a witness that this happened, does the owner have to worry about being sued if it goes bad?
Well, the only thing that the owner could possibly be sued for would probably be some type of false reporting if it was completely false. And they could then be sued for some form of defamation, for libel or slander, or saying something. There is qualified immunity for slander, for you testifying in court, meaning that you have greater protection. Now, if that same owner, however, has already written a letter complaining about the acts of the tenant, and it's false, I'm going to tell you that happens so rare, and I'll vet that out. Because when that owner comes in, I mean, if the letters don't match up, first of all, if the complaints seem like they're not making sense, probably your property manager is going to push back first and say, hold on a second, some doesn't say, these are just two owners who hate each other, and they're just making up stories against the owners, which we do see. And we've seen violations where I saw one time when I was at a hearing, and the person came in and said, you're sending me all these notices about these dog properties, I don't even have a dog. And then they brought in 3 neighbors and said, yeah, he doesn't have a dog, it's the person behind them. Well, why are they getting the notices? Well, the lady next door didn't like them, thought it was their dog. So some of that gets vetted out. I think it would be very rare to have somebody go to court and testify to something that's false. We just don't see that in these types of homeowner situations. If someone's going to take the time and effort to go to court to describe what's going on in their community, I don't think they have to fear that they're going to be sued at a later point in time.
Thank you.
Well, let me get just a couple more things that I want to cover in terms of the process. So you file a suit, the person disputes it as a trial. Unlike some of you may be familiar with assessment collection, that once the trial is completed, an order of possession is entered, and it's stayed anywhere between 60 and 180 days. Not the same thing for these cases. You're asking to have this person refill the property within 7 days. Excuse me. So the thought being, we need this resolved. And if the issues are, basically the concept is the landlord's not doing the landlord's job. The landlord is not taking care of the landlord's property, and the landlord is not removing a problem tenant from their property. So the association now needs to step in for the benefit of the other people in the and do the landlord's job for them with the tenant. I've had landlords call me and say, I don't even care about paying the fees. You saved me a headache. I wanted this person out anyway, now you're evicting me. I say, okay, well, you know you're gonna be responsible for all the costs and fees. I said, that's fine. I would have had to hire my own lawyer to do it anyway. This person, and generally that's always with, this person's causing a lot of problems. Oh, and by the way, they haven't paid the rent, so I have to get on. But understand, if you take nothing else away from what I have to say today, you have to put the procedures and process in place before you go to court. Going into court, one of the things courts are very big on is notice and due process. Notice is the rules. They enacted a rule, you let everybody know about the rule, you put the rule in place. Release it down. You had somebody sign and say, these are the things that I'm willing to live for. You had somebody sign something that says, I've received a copy of the declaration, bylaws, rules, and regulations. Those are the rules. That's important. So the court can say, you were on notice. You knew what the requirements were to live here. And then the due process afterwards, which was you violated these rules. And as a result of it, we gave you this 10-day notice. You had an opportunity to cure it. You failed to cure it. And now we're in court, and we're going to ask you to leave. Because that way, the person is aware of what they're doing, and they've decided to violate the rules. They've decided to break the rules, and they've decided to do whatever they want. Courts usually aren't very sympathetic to that. Now, I will tell you, courts are generally very sympathetic to associations. So that's always a hurdle to overcome when we go to court. You would think that, oh my gosh, we're trying to protect the benefit of everybody else who lives in this neighborhood. How can you not be sympathetic to us? I don't know. They think associations are this mean monster who's out there, jamming rules down everyone's throat and trying to make everyone's life miserable. There's a lot of people who are busybodies trying to control what everybody does out there. That's not my experience, but that's the perception that you have to overcome when you walk into the courtroom, unfortunately. So when you say to the judge, listen, judge, this isn't just us being a busybody. This is a real problem. And we feared these problems when we put these rules in place. And as a result of it, we've followed our own internal steps. Now we need your help in assisting the community of removing this person who's causing these problems. Courts are more likely to enforce that.
Very pleased to introduce our next speaker tonight, Officer Julie Smith, with the Naperville Police Department, is a crime prevention specialist. And she's, for the past 3 years, she served the city's crime-free multi-housing coordinator and has obtained certification as a security assessment specialist. Anybody who's in Naperville here, you should know her name, or at least you can contact her after today. She comes to Naperville with 7 previous years of experience as an Addison Police Department, and we're very happy, Julie, that you could be here with us tonight. Welcome, thank you. And with that, I'm going to turn it over to Julie.
Thank you so much, Tom, for inviting me to speak with you tonight. Again, I apologize for starting this. Just want to talk a little bit about the crime-free multi-housing program here in Naperville. How many people are property managers here in town? Few. Right. I'll talk generally and specifically regarding the program here in Naperville. The crime-free multi-housing program was started here in Naperville in 2003. Currently, we are a voluntary program, which is different than most other municipalities in the state of Illinois. I think it's just a handful that just have it voluntary. So here in Naperville, we rely on associations and larger properties to put it in their bylaws, put it in their rules and regulations, or some of the larger apartment complexes to voluntarily participate in the program, right? Currently, there is no ordinance within the city to mandate the program and make it mandatory. We have 10 complexes here in town who've gone through all 3 phases of the program, and 9 communities who have just implemented the first phase. And I'm briefly going to talk about that. The purpose of the crime-free multi-housing program, as Pat is alluding to, is to reduce crime, drugs, and illegal activity in the rental community.
Sorry, Julie.
Oh, no problem.
We were at a board meeting across the hall, so we just jumped in.
talked about, people needing to call the police. When do people call the police? When does that problem usually occur? It's not on Monday afternoon when that property management office is open. It's on Saturday night, right? That's when we get all those type of disputes with the loud music, or the people fighting, or a lot of weird things going on. So that's the benefit of the program is we talk to property managers, large and small, about ways to handle those conflicts and what to do. I kind of talked about a lot. So let's explain the program. Crime for Multi-Housing Program, it can be broken down into 3 different phases, right? Many people choose to implement only phase 1. What is phase 1? Phase 1 is education, right? In the city of Naperville, it's a 2.5-hour course. We offer this course about 6 times per year. Other municipalities, such as Aurora, make it a 6 or 8-hour course, right? This is our chance to educate property managers. Various topics are discussed. Crime prevention. What is crime? How to prevent it? What to do when you witness a crime. We also talk about security measures, about proper lighting, proper landscape. Right? Another aspect of the program is we talk about resident screening, right? How to screen properly for residents. What is a background check? What are you entitled to on a background check? Because when the police department runs a criminal background, we get a lot more information than the public when you pay for it on one of those sites. Right? So we give you information about those sites and where to go to get kind of live and real information. You can always contact the clerk's office at the counties to see if there's any pending court cases and such. We talk about the eviction process. A lot of landlords, they know about that 5-day notice, right? Because they're not getting paid. Many people don't know about the 10-day notice and the 30-day notice. Okay. So the class informs them how to go about an eviction and what the eviction process is. Lastly, really the heart and the meat and bones of that program is the crime-free lease addendum, and we briefly touched on it and it's included in the program. Right? But having your tenant sign the crime-free lease addendum, it means that if they are engaged in any type of criminal behavior, criminal activity, it is not only a criminal matter, but it's also going to be a lease violation. And they could be evicted for it. Not necessarily they're going to be evicted for it, but they could be evicted for it. And that's just not a crime that occurred in Naperville or whatever town you're in. If you get wind of they were arrested on a drug charge out of Chicago, well, that could be a lease violation. So it doesn't matter where that crime occurred, right? Now, we talked about guests. In that crime-free lease addendum, the person responsible, that tenant is responsible for their guest, right? So if their guest starts misbehaving, violating the law, there's your action to get, probably could be, get them evicted. Because that person who owns that, or who's renting there, is responsible for the guest. Right? We also talk about, and it's different, but we also talk about when that boyfriend, girlfriend, person who moves in stops being a guest and starts living there, right? A lot of properties have that problem or that question. And I think that needs to be identified in specific rules and regulations. Because sometimes it's like a 7 or 10 day, perhaps, if that person's been there that long, well, they're no longer just a guest. They're living there. And they need to be accountable. They need to have that background check. They need to sign, or they need to have a background check and go through all those types of checks and balances. One thing about having the crime-free lease addendum and in the rules and regulations is that it gives the person to have accountability for their actions, right? If they're misbehaving, there's going to be a fine, and something's going to be implemented. And people don't like fines generally. When that landlord starts getting fines for the tenant who's not following the rules properly. Absentee landlords, a big topic. We talk about the importance of always checking up on your property, right? check up on your property, you better have someone who can. Who can be the eyes and ears for you when you're not able to go there. We talk about having strong contracts. A lot of people with their units, through certain circumstances, they have to rent it out. And now they're the unintended property manager, unintended landlord. It's not their day job to be the property manager. And they just think, I'm just going to put an ad on Craigslist and I'm going to roll the dice and hope I get a good time. Right? So we really go over tips and resources and how to find a quality good tenant and how to screen for a good tenant. Because criminal behavior is not a protected class. Right? Criminal behavior is not a protected class. There are many protected classes. We all know gender, age, familial status, and so on. But in the state of Illinois, criminal behavior, so your past criminal record, you can use that not to rent to somebody, right? Many communities here in town who have the crime-free program in their rules and regulations, they merely state, do a criminal background check. A lot of larger properties who I deal with, they're talking about 300 to 400 units, specifically have in their contract, from the moment you walk in the door, when you're signing your name, your address, your social security number, they have that list of criteria, right? And it's going to be, your credit score has to be X. You cannot be convicted of these types of crimes, felonies, sex crimes, and so on and so forth. So they have that strict criteria of what they're screening for, right? That's how they don't run into trouble. But no, these are our rules. And as long as they treat everybody the same, they're not going to get into trouble. It's when you start going, oh, you know what, that was from a long time ago, we'll get you in, right? You have to have that same rule for everybody. You're talking about screening and yes.
Do you make a recommendation on where they should get the background checks from?
During the class, I give them a list of companies that do background checks, right? And then I always say take it with a grain of salt. Take it with a grain of salt. Okay? Good information in is good information out. Even as police, we have difficulty many times doing criminal background checks. You have a lot of like names. People lie about some names, if you believe that. And we don't know until we're done and look at the whole booking process and we get their fingerprints back that, lo and behold, there's an alias that popped up, right? Looks like, sound like names, aliases are lots of trouble sometimes. And you have to remember too that with the information that's public record is only convictions. Only convictions, which is different than what we see as police, because as police we see how many times this person's been arrested, right? So they might have been arrested for 10 times for battery, or aggravated battery, but they've only been convicted of it 2 or 3 times. And that's the information that you see. And then you also don't see too is, all right, well they were convicted of that battery, but did they plea it out? Was it an aggravated battery? Was that crime worse? And then now it's just, it appears as a battery or just a small theft.
How long do they go back after a background check?
Stays with them from their 18.
I'm just curious, for renting a place to sell.
Well, that's how long, the criminal background check will go. That doesn't mean that your criteria, if you might say, okay, within the past 5 years, you can't be convicted of a class X felony or anything like that. It's up to each individual board or what they put in the rules price.
I'm curious, town size of Naperville, that they don't make this mandatory. Is it, would you like to see it mandatory? Is it a city council, they don't want to get involved with it? But I think it's voluntary, you're just not covering everybody. You're just getting, and maybe not even a work experience.
There's a camera on.
Yeah, I know, right? It has been visited a few times by city council and most recently this past summer. As we know, we recently had an election and a new city council. The consensus was at this time, they wanted to pursue keeping it voluntary and continuing to grow it.
one source of revenue that's now leading the homeowner taxpayer. But if other municipalities and licenses charge a fee, an annual fee or something, I think it's.
It was, there was some, obviously there's pros and cons. I work part-time. So I work 20 hours a week. And so it's not only limited resources, so if you're gonna build a program, there's gotta be other things in place. So let's say, for instance, Aurora, they have, say, a program that has an ordinance for it. I think they have 6 or 8 people working on the Cranston multi-housing program, including 2 or 3 sworn officers, right? And then there's additional code enforcement that perhaps might be needed to be hired, right? So then you're talking a lot of manpower and those kind of issues. Not to say that when we did the program, we would want to make money off it, because there would be fees and things implemented, so we want it to be, you know, even. But I think when they looked at everything, they said at this time, you know what, we just want to continue growing it, and we've been trying to reach out to the homeowners and educate them regarding the program to get them more on board. Because a lot of times it's easier to probably do it that way. And I've heard from a lot of properties here in town saying, you know what, I've had some problems. How do we get this implemented? Rather than sometimes, you know, passing a big ordinance and the repercussions.
Plus, there's no fee for the associations to implement that.
Absolutely.
Yeah, but I prefer there should be a source of revenue. I don't know. I think it's a good thing that Aurora does it. I think it's a good thing we charge them the dollars for that area of information that they have for their license.
I'll keep you in mind and do another city code. Pardon? They had it started off in the homeowners advisory board, and they looked at it and they looked at reports. And then, I don't know if it got to city council or the homeowners advisory board, said, let's keep it voluntary right now, and we'll continue to grow it, see where that goes, and then we're gonna revisit the issue in another 1 or 2 years to see if we need to continue to expand it, or again, look at the possibilities of making it mandatory.
Hi, I have a question. Well, actually, our community does have it. We utilized it. And with the diligence of Pat and Judy last year and utilizing this, we were able to evict some undesirable people. And my question is that it really is a benefit. And I tell you, one person lived on my street, so I can definitely tell you it was a benefit. What can the public do to try to make this mandatory? Is there people we can contact or communicate to?
Absolutely, you can contact any of the local council members. You know, their information on our website. Some of your communities, I recognize some faces. When I talked about there's 3 phases to the program, a lot of them just implemented phase 1, which is education. Phase 2, for the larger properties that have 5 or more units in the building, I go out and do a security assessment called SEPTED, crime prevention through environmental design. Right? So I look at the landscaping, I look at the lighting, and I make recommendations based on safety. Right? The program also does have certain criteria that you need to adhere to pass that second phase. Once you move on from that second phase, you can do the third phase. Third phase is a safety social. You're like, okay, safety social. Getting the public, getting the community together is an important aspect of crime prevention. Neighbors looking out for neighbors, people looking out for people, right? Once you start to put names and faces with your neighbor who you never really see, you're more likely and more apt to call the police if you see illegal activity happening, right? If you see that moving white cargo van outside their residence, and you think to yourself, well, geez, our kids are ready to wait at school. Why would there be a moving van in the middle of the afternoon? You're more likely to call the police and have us come check it out, rather than waiting until 5 o'clock, 6 o'clock at night, or when you see them next to the mailbox, when hey, I saw a moving van over at your house, you know, someone moving out. So, getting to know everyone, right? That's the premise of that safety social, right? Once you do the safety social every year, then you're considered a gold certified property. You have obtained full certification. You're listed on the City of Eagleville's website. Then you also get the use of the crime-free multi-housing logo. I don't know if anyone's ever seen it before, a lot of renters have, right? So you can use this logo in your marketing material. I get phone calls many times from people relocating to neighborhood, looking for rental communities, or condos, that kind of thing. We are safe. First of all, it was a very safe place, but we don't live in a bubble, right? So I'm able to tell them that, you know what, there's a list of properties that participate in the crime-free multi-housing program, meaning they are being proactive about crime prevention.
Are there any other things that you can tell them about crime prevention in general? Some of the general things that they could do, such as lighting or those two programs.
Sure. I always talk about how to think good lighting is so important. All right? Burglars, criminals, they hate to be identified. If they think they're going to be identified, they're less likely to commit that crime. You want proper lighting, landscape lighting. Make sure the doors and windows are locked. That's a huge problem for us in Newport, believe it or not. People committing burglaries through open doors. We had a big rash of burglaries about 3 years ago. It was a professional crew. A lot of them were just targeting those open doors. Even after those events were highly publicized here in town, we had, like, our volunteer unit was going around and noting people who had open garage doors. I think within the first hour, they found almost like hundreds of open garage doors, unattended. Right? As individuals, we like to be very trusting, and, you know, we're mowing our lawn in the back, you know, we keep everything open. We need to learn, you know, to tighten everything up. So lighting is something we want to look at. Proper locks, utilizing the proper locks.
What do you think of cameras on condo or apartment buildings? Do you think that's a deterrent?
Signs, utilizing signs is a good deterrent. You know, you're being watched kind of thing. It depends how those systems are implemented and how they're used, right? Is it just going to go, is someone going to be watching it all the time? Or if a crime does occur, are you just going to see a fuzzy person with a hoodie on, right? So you're not going to be able to get anything of evidentiary value off of it.
And also be careful with placement. As well, an association could certainly put cameras in the area that's a common area or a common element. That camera should not be pointed in any direction that it could be looking at someone's unit or looking through someone's window or something like that, which may get to your result saying, well, what good are they anyway? We're just pointing on this grass or this sidewalk. Julie's, I think the biggest point though is, what are you doing with that? Is this going to a tape room that nobody looks at, or just it's burning a CD, or just saving data and it's only looked at in the event of a crime and then they go back, or is this something that's being monitored?
Yeah, I know there's, I think, some lawsuits. I think there was a sexual assault that was happening, and she was being, like, recorded, or she saw the camera. She's like, someone's going to see this, someone's going to come. And no one came because it wasn't being monitored. And I think a lawsuit eventually came from it. And I think of Walmart in their parking lots. If they have an inoperable camera, they put a bag over it. They let you know that it's not working. So there's no, like, expectation that.
It's the concept that once the association assumes some duty, they must perform that duty correctly. Even if it's a duty that's not mandated on them, but once they voluntarily assume it, they have the obligation to perform it correctly. If they don't perform it correctly and somebody's suffered damages, they can then be sued for negligence.
Well, one of our residents wanted to put up fake cameras.
I think that's terrible. Because it gives people a false sense of security. That's exactly what you were describing. That victim who thinks, oh my gosh, someone's coming, and lo and behold, nobody comes. I'd almost rather you see a sign that just says this property is being monitored, because monitor can mean anything.
Yeah. And more often than not, I think a lot of people want to jump to the conclusion when we put a security system or some kind of cameras up. That's the first thing criminals like to take out.
One association where they just started with cameras to 10 buildings, and they don't monitor or nothing. They just say, probably should have.
What do they do?
if someone breaks a door or something, then we can look back and see
Right.
who broke it. If the light got broke, we can look back, see who broke it. They're timestamped, they can go to different hallways, but they're not monitored unless, like you said, something happens, then we can see what unit they came out of or so forth.
It could be helpful.
You know, I'm gonna give you the advantage of the cameras because we have a few. And the placement in our building works to target specific problems that I have had those talking about here. What we learned was once people became aware that the camera was in a certain spot, they typically stopped. It also helped us prove to a mother what her kid was doing. And we've had recent issue in our building with mischievous vandalism everywhere in the building except three specific spots that those cameras face. So what we include for cameras, and I understand about responsibility and do they really work or whatever, we look at it as a deterrent because apparently people in our building are not all adults and don't want to act like adults. But if they're told, we can see who did that, then the behavior will stop. Our problem is, we have a big building, our little three cameras are never going to do anything.
You said it right, it's a good deterrent, but there's lots of other deterrents too. So when we talk about, lighting, making sure it's a low light, it's also education. When and why to call 911. How many people voluntarily go, oh, I see something going wrong, I'm gonna call 911 right away. You know what? They don't, we need to pass it on to homeowners, renters. If you see something, you know what, don't brush it off. Call 911, you can remain anonymous. We don't want to come knocking on your door asking you your name, your birthday, and your blood type for a loud music call. We want that call to stop. The problem activity, the illegal activity to stop, come out. If there's something major, yes, we'd like to talk to you. But for those kind of similar calls, you can remain anonymous. Just notify the police of that people loitering. Okay, well, let's give a good description. Look. Clothing description. What kind of car are they in? Because then we can, if we see them on the way out, when we're on our way in, we can stop them. Ask them what they're doing there. I smell something funny. Can I search your car? Yeah, bing bong, we've got a nice drug bust. That works.
I got a question for you. You talked about monitoring the cameras.
Yes.
You're just having it record. Should you go back like once a week to look through it? Once every 2 weeks, once a month, twice a week? What's a good rule of thumb?
Oh, I would do it when there was something that happened. So, I mean, if you have vandalism in the hallway, or you have damage to a door, or you have a complaint from a homeowner saying that there was, somebody running up and down in that area, or somebody had damage to their car, then you'd go back and look at it. Otherwise, I mean, if everything's running great and nobody has any complaints, then you can walk around the property and say that it's excellent. I don't know that I'd waste my time looking at videotape or at data that's basically being saved. But that you can, but I don't think, I would focus more on an event more than anything else.
I have a question, I think I know what the answer is going to be, but, so our property is in downtown Walmart, and we have a secure front door, so if you want to get entry, we got it buzzed up, back door for deliveries. Now, we've got two things in the rules. Number one, all deliveries have to come to them. Two, don't open the door. And apparently the adults in the building just somehow can't read it. So we've done the folks, it's a secure building, et cetera, we've tried to find them, but, we've had burglaries in downtown. We've got a couple of armed robberies with 7-Eleven. We put it in newsletter saying, reminder, do not open it. It's just, we want to keep the building safe. And it's just, I feel like I'm kind of this self-imposed rule police, because I see someone propping the door open, and I'm like, please don't do that. And they're like, well, but I need to get in the door. Like, then shift. Are there other suggestions to get this concept across to our customers? Short of, I'm going to have to suggest, if we have to ask more than twice, that, don't prop the door open, we're just going to start finding. As a small building, we just don't want to start hitting people in the head, but just not. I'll look for any other comments if anyone's had any.
If somebody has the answer to get people to behave by the rules that are in place.
$250 fine works wonders.
So often, and lots of more than things. And it's that unattended person too, when you have a delivery, not having them come up or escorting them.
Right.
Because once they're done, let's say your maintenance in your unit, you say bye and thank you, well, they're going to keep going in the halls. So, a lot of education.
You know, they were joking a little bit, but they're really not. Because I know you say, you know, who wants to really give a $25 fine? It seems like so petty, and it's my neighbors, and we all live in the same building. But it does get results. It really does. If somebody gets a $25 fine or a $50 fine, especially in a small building, but while they will probably cuss at you under their breath for a little while, the door's probably going to be closed the next time.
Putting in the newsletter 2 or 3 times has not generated.
Because the people that need to stop doing it don't major mistakes.
Just like when we talk about crime-free, it's accountability. People don't start playing by the rules until they start taking fines. Until it hits their pocketbook, that out-of-state landlord or that landlord will start taking action, going, you know what, I need to step it up a little bit with my tenant and get them on board with the program with the rest of everybody else.
The problem with that is you can find people sold to the zoo as long as they aren't absolutely something to be about. Either a homeowner or a landlord. That the fines don't mean anything if they don't have the state.
Yes, they do at some point.
At some point, but what point? What point do you get grizzly?
You know, the reality is, you're right, and it's unfortunate. And it's not because the law doesn't say it. The law actually does say that fines become part of the common expense attached to a person's account, just like unpaid assessments, and you can sue to collect those funds. The reality is, going into court and having somebody be current on their assessments every single month, pay all their other bills, pay all the chargebacks, and only have fines on their accounts, the judge is not going to be happy with you in court, and generally will not award those. Typically, at my office, we would say, geez, wait till they're delinquent on just one assessment. And so then we can finally get into court and say, we went after not just the fines on this, because going after fines alone, unfortunately, becomes problematic. Now, that doesn't mean you waive them off their account. They sit on that account, and when they sell, and they're at the real estate agency, they got to pony up that money to pay that. That's why if it is a landlord, just accruing $25 fines every month isn't as effective as their tenant getting a 10-day notice saying, you know what, your tenant's gone. Because now it's not $25 that they don't know what's going to sue them for. Now it's loss of rent next month. And that's a big amount.
And plus, surprise the tenant.
Tenants usually,
Whoa, what's this?
I've actually had tenants just leave. Oh, I got this letter, it's from a lawyer's office, it says I gotta be out in 10 days. Okay.
I think that's what all of ours do. Does the person who's late on dues, what if they pay part of their month's dues, but leave half of it unpaid? Does that count as unpaid?
Counts as unpaid.
Just like if they only pay half the rent.
Right, yeah.
Before we let everybody go, I thank our guest speakers again. I have a couple of things I'm going to add a little off the agenda here because both Pat and Julie brought up some interesting points and kind of looking at it a little bit from a manager perspective. But I think the best security measure that you have out there is each other. And being aware of each other, and being aware of each other's habits, you know, how you live, people who come and go. Pat mentioned it, Julie mentioned it, get to know your neighbors. You know, kind of watching out for each other is probably the best thing. It's about the best security measure you can use. I'm a big, managers, we're all big proponents of lighting. It's cheap. It's very much a deterrent. I mean, you know, Windridge has got probably the best lighting I've ever seen in an association. So if any of you here in Naperville want to go over and take a look at the association, it's amazing. And the other thing I think I want to say, and Pat mentioned it, and again, Julie mentioned this also, but it's important, call the police. If there's a problem, don't hesitate. You know, and Julie said it can be anonymous. That's wonderful, but do it. Just, I mean, these ladies and gentlemen that are driving around in their squad cars are here to protect you. They're here to protect your property. They want to help you, or they wouldn't be in the job they're in. So don't hesitate. There's no such thing as a bad call, is there?
Go for it.
That's, yeah. That's right. It's very exciting, let me tell you. Very exciting.
One of the other things you can do as a board member or the president of your association, you don't have to go as far as a FOIA with your local police department. If you have any kind of interaction with them, you can ask to have them sit down and show you, for whatever time period you want, all of the calls or the stops that they've made in your association. All they have to do is redact the names. But you can see where they went, why they went, and how many times they've been there. I sit down once a year with our police chief and I go through that. And it's amazing that I find out that they're actually there 3 or 4 times a day, not going to somebody's address, but actually going through the neighborhood, which is nice to see. But when you see a certain address pop up time and time and time and time again, that you may not know it because it's during the day when everybody's gone, that also helps a lot.
Right. And Nance, I didn't touch on this, but here in Naperville, if you've gone through all 3 phases of the current multi-housing program, you get a monthly report of all incidents that happen at your location. Right, so there's both police and fire. And then that property manager, she's like, oh, you know what, tell me a little more about that loud music call. Or what happened, what about that repossession? You know, why that property manager wants to know who got their auto repossessed? Is there probably not going to be a rent? Right? So it's keeping tabs on their property. That's not, absolutely, you can FOIA, a FOIA request anytime. Certain information is not given out, like juveniles, that kind of thing, but you'll be able to get the gist of what happened at that property.
And one other thing, I mean, have your boards reach out to the police department. I've been at numerous board meetings where it's once every 4 months or something that a police officer just comes in and says, I'm the community police officer for your community. I'll just let you know what we've seen and what we haven't seen and different things that you could do. I mean, you establish that relationship in advance of the problem. It'll be a lot easier to solve the problems when they come up.
To take that one step farther, I would like our managers to do that. The managers should go introduce themselves to the police chief. The managers should go out and introduce themselves to the fire chief. You know, because it's a good thing. It's not a bad thing. It's a good thing. So, like Pat said, the association presidents, the boards, invite them over to a board meeting, whatever. I think that's exactly right. Jack.
Yeah, Tom, you're involved with management of properties both downtown and in the suburbs. I was wondering if you could comment a little bit on what you see with the so-called Airbnb problem, and is it spreading to the suburbs?
I have not seen it in the suburbs, Jack. It is a bigger problem down in the city, and a lot of managers will actually go on the websites for their buildings to find out if there are owners that are advertising as Airbnbs. I don't know, maybe Pat has seen more. I haven't seen any.
I've had one.
Do you? Okay.
And I took a screenshot of the ad and sent it to the owner who had no idea his brother was renting it out. Not
Well,
Quinn
in the
Rich.
city, it's
So
very
it's-
rough.
And it's a good point because everything we've talked about creating these rules for leases and all this stuff, when someone's renting a unit for 3 days and it's just on and off, you're never going to get that information. Which is why, and Jack probably knows this, the city of Chicago does have an ordinance. The problem that they're experiencing is no one enforces it. So there's a tax, there's a registration requirement, there's a municipal ordinance, but they're not enforcing it. So the people who are really pushing the enforcement are homeowners associations. Guess who they are? Hotels. Because they're seeing loss of revenue as a result of that. So that's really where we're going to see the big push to regulate Airbnbs in communities where there are a lot of hotels who are potentially losing revenue because someone's paying a couple $100 as opposed to, 6, 7, or Chicago maybe $1,000 a night. They're renting a 4-bedroom condo for $300 a night.
This is kind of a broader question. We're a newer community, and right now we're in the process of trying to strengthen our security, both external and internal. Kind of whatever we feel our developer was kind of strengthen that, whether it's change in our key system, as I mentioned, cameras and so forth. We're having a we are not in Naperville, our police department does not have this program. We do have a good relationship with them, but they really don't have the resources to do this. So I'm just wondering.
If you want your manager to talk to me, I can give you some companies that are.
Okay. Does anyone else get to go through this process?
Comp plan for security? No.
Well, I want to thank both of our presenters, Julie and Pat, for being here today. This was a great start to get all of you thinking. You can talk to Pat about how to put the leasing addendum into effect. I think the program that Julie runs, the three-phase program, is something very interesting. I'm sure she can tell you more about that in detail if you'd like to. I thank you all again for coming out on such a cold night. Thank the ACM people for being here, and hopefully we'll see you at the next one in a couple of months. So thank you very much.